plaintiff's theory in this case and what they've spent a lot of time talking, obviously I'm addressing the accident itself and I'm addressing the issue of whether the store did anything wrong that's been proven by the greater weight of the evidence to cause this accident. Their theory is a theory. I understand it. I'm not going to make light of it, but I want to point out that it's a theory. Here's what it is. It's that there must not have been umbrella bags handed out. They don't have actually evidence that they weren't. They're working backwards from the fact that a couple umbrellas are shown without umbrella bags. So there must not have been umbrella bags handed out. We're going to speculate about what time the different people entered the store that didn't have the umbrella bags as shown in the video at that exact time with relation to when it started raining, which is unknown. And we're going to ask you to speculate and assume that dangerous, dangerous word in a court of law. To assume, well, it must be because they asked or wanted to get an umbrella bag and couldn't get one. Walmart wasn't there handing out umbrella bags. All of those 4 points are assumptions. Put differently, there's no evidence. No evidence whatsoever, apart from the fact that, gee, let's look at a video. There's 2 umbrellas without umbrella bags. Let's make all kinds of assumptions from that. That's not the only point I have to make about the liability case, but I wanted to start out telling you that. I mentioned that because I wanted you to understand what we mean by umbrella theory. But now let's talk about the exact thing this slide shows. It's a very crucial point I would submit to you. After the 2 people that plaintiff's counsel hinges their entire case on that are shown with umbrellas, one of which is open and she's doing something with it, absolutely admittedly no bag, and another one, a guy has it down and let's call him swinging umbrella guy. Those are the 2 people we're talking about. After they walk through there, by my count, and you have the video, you're going to have the video, you're going to be able to look at it. Hopefully you're not sick of it already, and you should look at it. There's, I believe, 8 people that walk over, customers, through this area. No issues whatsoever, no slipping, and I haven't even gotten yet to the size of the spill and the difference between what Mr. Portier talked about. I'm just talking about water in general. No slipping, no looking down at their feet, no going like I'm doing here, like kind of walking around it. None of that, not one person. And you know who else is in that group? I'm not suggesting that the plaintiff walked exactly over the spot where she would later fall, but included in this time frame. So between the 2, let's call them the umbrella people and the accident, included in that 7-minute span, plaintiff and her husband on their way into the store walked by this area. They're a few feet away, but they walk by. That's where this discussion with her came up, where Miss Absulu started talking about, Miss Absulu started talking to me when I was asking her about this, about how she doesn't walk looking down. That's fine. It's not really what I was asking her about. I was merely asking her to acknowledge that there was no water there when she walked by. I guess theoretically I'll say, and even if, well, if there was, she missed it, and that goes towards comparative fault. But that's not really what I'm saying here, folks. There wasn't any water there. There wasn't any water there.